after refusal, the centre has now informed the Supreme Court in an affidavit that it has decided to re-examine the provisions and validity of Section 124A of IPC that criminalizes the offence of sedition. The centre has stated that in tune with Prime Minister Modi's notion that at a time when we are marking 75 years of independence, it intends to work towards shredding colonial baggage. In that spirit, the centre submitted that it has scrapped 1,500 outdated laws since 2014-15. Affidavit further stated that it has also ended over 25,000 compliance burdens which were causing unnecessary hurdle to the people. Notably, the government has now requested the Supreme Court to not proceed hearing the pleas against the Section 124A as the centre will review the law. Interestingly, on Saturday, the Modi government had defended Section 124A and stated that Supreme Court verdict in a case in 1962 had stood the test of the time and there was no need to refer the matter to a larger bench.
Obviously, this should be seen as a positive development. Let's not forget that over the last 7.5, 8 years, Narendra Modi ji's government has worked to remove over 1,500 archaic laws that were not required. These statutes or these sections were not required. Therefore, there is an attempt of the government consistently to ensure that the environment should be such that the business community, or in this case individuals, whatever needs to be done to make it easier, that should be done.
But let's first understand what is sedition law. The law was drafted by British historian and politician Thomas Macaulay in 1837. The sedition charge was included in Section 124A of Indian Penal Code in 1870 and was defined as an act by whoever, by word either spoken or written, or by sign or by visual representation or otherwise, bring or attempt to bring into hatred or contempt or excite or attempt to excite disaffection towards the government establishment by law in India. It was imposed by British colonial government to primarily suppress the writings and speeches of prominent Indian freedom fighters. Writings of leaders like Mahatma Gandhi, Lokmanya Tilak and J.C. Bose were suppressed, and they were even tried under sedition law for their comments against the British rule. According to the Law Commission of India's 2018 report, while framing the Constitution, the Constituent Assembly opposed the inclusion of sedition as a restriction on freedom of speech and expression under the then Article 13. It saw the provision as a shadow on colonial time that should not see the light of the day in a free India. However, the offence remained under the Section 124A of IPC. The report concluded, and I quote, "In a democracy, singing from the same songbook is not a benchmark of patriotism." The statement further said that Section 124A should be invoked only in cases where intention behind any act is to disturb public order or overthrow the government with violence and illegal means. In July 2021, the Chief Justice of India, N.V. Ramana, made an unprecedented judicial criticism of the way sedition law was being used by the government and asked why the colonial law used against Mahatma Gandhi and Bal Gangadhar Tilak continued to survive in the law books after 75 years of independence. The CJI is not the only one to criticize the law. Several opposition leaders have also questioned the misuse and validity of this law. So let's take a look at what has happened in the parliament so far. In 2011, CPI MP D. Raja included a private member bill in Rajya Sabha proposing that Section 124A of IPC should be omitted, but failed to pass it. In 2015, Congress MP Shashi Tharoor introduced a private member bill in Lok Sabha to amend Section 124A of IPC to term only those actions and words that directly result in use of violence and incite violence as seditious. As per the National Crime Records Bureau, the 2019 data showed that there was 165% jump in sedition cases. According to the NCRB data from 2014 to 2019, total 559 people have been arrested under sedition, while 337 cases have been filed. However, the conviction is quite low and stands at 10. The latest sedition application of the Union government comes at a time when Supreme Court is scheduled to hear an argument on the legal question whether the pleas challenging colonial era law should be referred to a larger bench.